Good evening, everybody. Today we're going to talk about the Gold Card Proclamation. Well, not proclamation, it's the executive order that was also released on September 19th, 2025, along with the $100,000 H-1B fee. So today's focus is the Gold Visa, or the Gold Card executive order. I'm Sam Shihab with the law firm of Shihab Burke is with me.
Brian Burke from Shihab Burke. It's Wednesday at 6 p.m., which means we're here to talk about interesting issues in immigration, and this sure is an interesting one, Sam.
Yes, so there has been a promise of a gold card.
Yep.
You pay money to get residency in the U.S. That's different from the EB-5, the complicated EB-5 program.
Yeah.
And all the experts have been saying, I don't see how that can be done.
I was saying, how? It seems like you have to change the law.
Yes.
Yeah.
So then we have this. We have the executive order that's been released giving the Commerce Secretary, Homeland Security, all the cabinets 90 days
Department of State,
to come out with some laws, some regulations to make this happen.
Yeah.
And the way this White House is trying to do it is through EB-1 and EB-2 national interest waiver.
Yeah.
So at the outset, before we go anywhere, because there's a lot to talk about here, at the outset, they are subject to the visa bulletin.
Correct, yes.
And the visa availability. So if you are from India, born in India, and if you were born in China, and you want to do this 1 million, 2 million, and also there's a 5 million deal,
To be talked about, yep.
which is not clear, you are subject to the visa availability, and that cannot be worked around.
Correct.
That I can see.
But counterpoint is, I would bet there's tons of people in our audience right now who are, in the EP2 category with, 2016, 2017, 2018 priority date, who would absolutely jump at the chance to upgrade to
By
EB1.
handing the government $1 million.
Well, by handing the government $1 million, they might want to negotiate that number a bit. But I mean, they would be thrilled. There's a lot of people who would be greatly benefit from that.
Right.
So,
but if you're an outside the U.S. looking in and say, hey, I can pay $1 million, and you're not here in the U.S. And if you're born in China or in India, it's a long wait.
Sure. So the backlog is for China's bad, and for India far worse.
It's not terrible, but it's
EB1 is not too terrible for either of them, I guess. Yeah. So,
and why did they give the EB1 and the EB2 option? Why do you think they gave both? I'm confused.
I will fully admit that I am as well, because why not just
EB1?
EB1, yeah.
But why would anybody do a national interest waiver?
Well, especially, national interest waiver is not particularly useful for people from India because, well, congratulations, you're in the EB2 category. You would have been better off in EB3. But for people from a lot of countries, EB2 is super attractive because the wait time is minimal.
It can backlog sometime.
Yeah, this is true.
Why would you not take the EB1 versus the EB2? But maybe that's... And then
I'll give you a simple answer, because it's something we have to talk about here. Is this policy seems subject to challenge, and taking multiple chomps at the bit, multiple attempts to get this through, might be a strategy to do it, to accomplish it.
But both options run on the same engine.
Well, they run on slightly different engines.
You shut down the engine, the options goes down.
Well, I guess you've invited me to talk about engines, Sam. So I'm going to maybe talk a little bit about how it's implemented.
Okay, so let's get an overview for everybody.
Yeah. So they basically, the executive order says for a gift of $1 million to the Department of Commerce.
Irrevocable.
Irrevocable, yep. Irrevocable gift to the Department of Commerce. We should consider this donation as positive evidence as one of extraordinary ability under the EB-1A program, right? As well as evidence of eligibility for national interest waiver under the EB-2 national interest waiver program. Now, the thing that's to understand about the EB-1, let's pick the narrow example of the EB-1A program. The EB-1A program, we're just looking at the law. It's available for people who have extraordinary ability in the sciences, arts, education, business, or athletics. And this policy specifically says we're going to consider that donation to be evidence of your extraordinary ability, in business. What do you think of that, Sam?
Well, very problematic. I mean, if you tell me what's the law, what's the foundation of this executive order on the gold card, I would say that the foundation is very
Subject to challenge.
shaky,
Yeah.
very shaky, very weak. I mean, I don't equate $1 million, especially today. I mean, $1 million today is really not a lot of money.
Sure.
And it has nothing to do with science. It has nothing to do with business. I mean, you can win $1 million in the lottery. You can inherit $1 million.
Yeah. So
you could be a person that do not know how to read and write, never run a business, has no scientific background, never run no business acumen, and your athletic skills are non-existent. You could be also a person who is so not coordinated that you cannot even.
well, it's limited to business. It's limited to expertise in business, but still, I accept the
But
premise.
this is the list.
Yeah.
Athletics, one of them, and have $1 million. So
Well-
I don't see how you can connect them.
Yeah, and I agree because ultimately this executive order says, hey, Commerce, Secretary of State, Homeland Security, you have 90 days to figure out a policy to put this into effect. And that's going to be regulations. It's got to be, right? And the rules for regulations, generally speaking, they have to have some relation to the law. And the sort of the fun thing that I'm thinking about when it comes to this is the concept of Chevron deference that we probably talked about here maybe about a year ago. It's that previously, historically, courts would be very differential to the government agencies redefining what the rules are for a process because they're the experts. And due to a change in court policy facilitated by the president's changes in the courts, I think this is very subject to challenge, basically under the premise that, like you said, having $1 million in no way reflects that you are of extraordinary ability in business or that you are doing work in the national interest. Favor.
And it's too early to say, but I agree with your point. I mean, definitely it is wide open to legal challenge. Now,
very fun one to watch for sure.
Yeah, it's definitely a very weak executive order. But the problem I have with it, the second problem I have with this, Brian, is unless they give you some kind of a refund mechanism, because they can file an adjustment of status and you could get an adjustment of status denial.
Yeah. All this covers is the immigrant petition, the I-140, essentially.
Yeah, you get an approved I-140, you pay $1 million, and then you file an I-485, and they say, oh no, you have unlawful presence. You have a criminal background. You have. Yeah. And then they can deny that, and they say, thank you so much for the $1 million.
I love the money. I love it. Yeah. Thanks so much. Adios. Yeah.
So I guess there's three types of audiences here, or potential customers to this.
Ooh, I like your analysis on that part.
Three potential customers. People living in the U.S. On H-1B who have prior.
Would love to upgrade to EB-1, sure.
Yeah. People living outside the United States with a lot of money, very rich people, who would like to have some kind of a visa to the United States on an extended basis. Sure. And then the third one is kind of a maybe sub of the second one, is people outside the United States who are undesirable, people who are connected to organized crime, people are connected to bad things, who have questionable background. There is nothing here that says the $1 million will be vetted.
Well, so I was thinking about that as well.
So on the third one.
Yeah.
And I'll just leave that alone because they can probably clean that one up.
Well, I think it would have to mirror the rules for E2 visas and EB-5s that require that your money be lawfully sourced, right?
Yeah,
if I had 90 days to write new regulations to cover a very complex issue, I'd be scrambling to borrow parts from other similar visa programs.
The super rich, this is where I think they were trying to think that they can bring a lot of people from outside the United States who are rich, who can come in and are not interested in a green card.
Yes.
People who her net worth exceed a certain magic number, I do not know whether it's 200 million, 500 million, 100 million, or more. There's a magic number after which these people are not interested in a green card. They're interested in a residency in the U.S.
But not the unpleasant parts for them that come with that, like, say, taxes in the United States.
Yeah, worldwide taxation.
Oof, yeah.
Which is huge for them.
Yeah.
So these people are not interested.
Yeah.
And then the other group are here in the U.S., living in the United States, will pay $1 million. Maybe you'll get some of those people, but money doesn't grow on trees. These people are hardworking people who are on H-1Bs and L visas, had salaries, and have homes and kids in school.
Think of this stuff though. Think
of
somebody in like Southern California though. I got a house that's a regular house, but it's worth $1 million. You can sort of scrape together money from point A, point B, point C. You might be able to get there. But again, that's sort of the
Sell
nuts
the
and bolts
house.
of this.
And sell the house for the green card. That would be sad.
That would be, yeah.
That would be very sad. But
Well-
but that's how I see it. I mean, it is definitely and then Congress is not happy with I mean, there's been a lot of negative commentary from Republicans and Democrats right after they came and said, we don't understand what the president is doing. It's our job to create law. He seems to be stepping his bounds. So there's some of that commentary that came out. So there's negativity on that already. So we will. I mean, I will wait and see.
Yeah.
I'd love for it to work. I'd love for people
I'm always
to,
for more immigration
to get
options.
the gold card.
And I am very fascinated by the way they've done this. I was really wondering how they were going to accomplish this without changing the law. And when I read this, I said, oh, that's kind of fun. They're going to kind of muck around with EB1A and EB2 national interest waiver. Fun.
What we haven't talked about is the $5 million platinum card.
Platinum card.
The $5 million platinum card is not in the executive order, but it is on the White House website. And it works with giving people 270-day right to live in the United States without being subject to taxation. Now, that is attractive, but that did not make it to the executive order because there is no mechanism.
Yeah. The difference is this one they were able to attach to the EB1A and the EB2 national interest waiver, and creatively indeed. And as soon as I heard about the platinum card, I said, well, what program are they going to attach that to?
But there's not a green. It's not a green card. It's a right to stay in the United States for 270 days. I mean, it could be a B visa.
That's you know, yeah, that's where we're
But you
jumped
have to modify the tax law because under U.S. taxation, I think if you're reside in the United States for
a certain amount of time,
180 days or 181 days,
whatever it is,
you're subject or something. So interesting.
Yeah.
So that's where we're at with the gold card, guys. Nothing. Don't call me to process a gold card for you. There is no such thing today, September 24, 2025. December, January 2026, maybe we have something. We'll wait and see.
Well, I think we might know in 90 days what this.
That's why I said January. Yeah.
Geez, we're that close to January. You're right. Yeah. All right.
Yeah.
All right.
Crazy, right?
Love it.
All right, so let's go ahead and take questions. We have some questions from immigrationquestions.us. We have some questions. One gentleman here posted a question online, so we'll take.
We'll take a live question.
Rory,
online.
yeah. Came on K-1 visa 14 years ago, then got married within 1 year. Unfortunately, the spouse refuses to file I-485. The spouse died 4 months ago. Can she file a widow for the U.S. citizen petition? That's a big one because you have to file within 90 days.
Yeah, as I recall, when you enter on a K-1 visa, the only path for you to get permanent residence is through the spouse that sponsored you.
Yeah. Obviously, a widow petition to begin with is a discretionary petition.
Yeah.
And I would be interested to know whether or not you've lived together during the 4 years.
Yeah.
And if they know that you've never lived together for the last 4 years, and the fact that she was not interested in filing your adjustment, I don't see how that discretion can be exercised favorably.
Yeah, I mean,
especially with this administration that we have right now, they're not exercising.
Discretion is an unpleasant
They're
word.
not exercising. Yeah, the discretion does not exist in their book. All discretion is a no answer right now.
Yeah.
So I'm skeptical.
Yeah, when I think of this, I mean, I think there's a lot more facts out there. I mean, refuse to file the I-485. I want to question. It's not a pleasant conversation, but it's, you know, I worry about, is there an abuse situation here? Because that might open the doors for, you know, a VAWA-based case, which are relatively rare. But you know, I wouldn't want to wish those upon anybody. But there's a whole lot of things here, and that's the sort of thing where I think we always have to say you got to really kind of talk to somebody in detail, because this is the sort of conversation where I could have an hour-long conversation with somebody about, you know, and tons of research and thinking about it following the follow-up as well, you know? Yeah.
Absolutely.
Yeah.
Yes, live together.
Yeah.
So, okay, good. That's good news. I mean, obviously, the question, why is she not interested in filing an adjustment for you for 4 years?
14 years ago is unless it's a typo.
Yeah, 14, yeah.
And died 4 months ago.
Yeah. That's a big question. I mean, that is a big one.
Yeah, it's the widower petition is also yeah, again, this is the sort of thing where part of me being good at my job is knowing that I don't have every immigration rule and loophole in my head.
I mean, if it hasn't been filed for 14 years and she didn't wish to file it, how can you say, as a dead person, now we can get her to file it because she's a U.S. citizen?
Yeah.
I mean, I'm skeptical about the whole thing here. This 14-year deal it makes my head spin.
Yeah.
Did not file it, so it sounds like a little bit problematic in my opinion.
Well, we have plenty of good old questions from our immigrationquestions.us website, which makes it a good excuse to push that immigrationquestions.us button and remind everybody that immigrationquestions.us is a website that we have. It's a .us domain, and I haven't pushed the button properly, I guess, but there it is. I got it. And go there, type in your questions, send them to us. We will do our best to answer them for you. If you have questions in the week, this is where we'll get them.
Yep. Yeah. So you got one here for us?
Yes.
To post?
And paste. Nope. Oh, can't get it in there, but we're just going to read it live here, and that's fine. If H-1B renewal / amendment has already been approved before the proclamation, or any future have already been met with H-1B quota in the past years, are they subject to the $100K visa fee due when going for a visa renewal at the consulate? So what I'm hearing is, if I'm going to interpret this as somebody already has an approved H-1B petition filed before the 9/21 implementation date, it's not supposed to apply to you. However, we're still on the camp, at least I am, of maybe now is not the best time to travel as they figure out what this policy actually means in practice.
Which we will find out pretty soon.
Yeah.
I mean, this is not going to take too long, but yeah, but the plain reading right now that it will not be applicable, correct?
Yeah, I agree. Yeah. Let's see what else we got from immigrationquestions.us. Let's see here.
You can read that out. You don't have to put it in there.
Sorry. My husband got selected in the H-1B lottery. Both our files received the date is June 18th. We switched his application to premium processing on September 14th. We're changing our status from F1. Do you think my H-4 would be approved at the same time with his application? Can I drop off my school when his application is approved, or wait until my H-4 is approved? This is one we might have gotten to.
Yes, we'll answer that again.
Yeah.
Go ahead, Brian. Give it a
So,
shot.
I've totally forgotten the content of that question, but
Yeah.
it's,
Well,
you should maintain your status until your current status.
H-4, my husband's H-1B is approved. My H-4 is not coming yet. Can I quit?
Can I quit my current F1 status while waiting for my H-4? And I don't think my immigration attorney's answer is always, 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 you should maintain your status as long as you can. Don't count your chickens before they hatch, meaning don't presume that your case is going to be approved, because you just don't know until you get that shiny notice in the mail.
Yes.
Yeah.
All right. Sounds good.
Yeah.
I moved from H-4 to an H-1B in 2023, but I don't have a stamping. Do you think the $100,000 fee is applicable to me because I don't have stamping? And the answer is no, based on our current reading of the regulations.
Yeah.
You are not subject to the $100,000 because the filing was pre-September 21st, 2025.
Yeah. I'm going to try to get some of these other ones that are later, as I don't think we got to these last time. Here we are. I'm getting ready to file my I-45 EB-1B. Oh, that's a fun category. You likely scientist or researcher. I approved in 2025, but I have an NIW priority date from 2020. I have a moving violation, speeding, fine of $75, state of North Dakota, and 2 parking tickets for $115 and $65 in NYC. I had an accident, which was not my fault, and I didn't get any violation as it was the other driver's fault. I will be mentioning about the speeding and parking tickets at my I-45. Will this affect my green card?
The answer is no, it will not affect your green card based on the facts you presented.
Yeah.
These are minor incidences. None of them are in the category of moral turpitudinous crimes or felonies. You would be just fine under current immigration laws.
Yeah, I mean, the only thing that sort of raises my eyebrow ever so slightly is just as general information for the people out there. They do have interest in, accidents where there's property damage, but I don't see it coming up for you because it does not appear that you were cited, and thereby they don't have the means to sort of ask about that. Yeah.
So this is more interesting here. Yeah. We have EAD advanced parole until 2027. Their adjustment status application filed in 2022. I have 2 DUIs. One in 2014, the case was closed, and one is still open right now. We did mention the 2014 DUI in my adjustment status application and provide all documentation pertaining to it. Should I anticipate an interview when my mandate becomes current, and what are the chances of denial deportation during the interview? Okay, so bottom line, I got a pending green card application. I have a 2014 DUI, and I have a DUI right now. Mm-hmm. How is that going to affect my adjustability?
Well, adjustability, I haven't read the particular laws. This person has been, let's say one maybe convicted other, and the other one they're being charged with. It's unlikely those crimes are going to be considered morally turpidous. However, what's interesting to me right now, Sam, is the discretionary component of adjustment of status. How do you think that might factor in something like this?
I don't think is going to change because discretion has to be by policy.
Yeah.
And there is no policy right now that says change how we've been doing business on these criminal background cases.
Yeah.
So I don't think discretion is going to be a problem. He should hope that his adjustment does not come out during the Trump administration, because they sure do know how to find creative ways to make things difficult.
That's a diplomatic way to put it, yes.
For people who have, a couple DUIs. I mean, you're not one of those people that they would like to help. Yeah. Let's put it that way.
Yeah.
Be that as it may, wish you luck, but clearly do not walk into the interview without counsel. And you definitely need to do your homework and be 100% prepared for the interview.
Maybe check out some more of these live questions here.
Sure.
So, my spouse has a recently approved I-140 and H-1B. I'm currently on L-1 and like to move to H-4 EAD. Should we file the H-4 COS and EAD now, or wait to bundle with my spouse's renewal next year in premium processing? Well, I think in this present climate, you are less likely to see the H-4 and EAD approved at the same time. And the processing times for H-4s and EADs, I don't believe they're too bad right now. I mean, depends upon if you'd like to be on it.
5 months, give or take.
Yeah, I think it's around 5 months. Meaning, if you'd like it now, well, I'd like you to have it now, but now doesn't seem very likely. But it seems to be to me to say file it now, maintain your L1 status while that's pending, and when your H4 and EAD are approved, you're on H4 EAD.
I think the timing, I'm assuming everything else is equal, meaning that the employer doesn't care, right?
Yeah, sure.
I sure like her to be on H4 EAD sooner, because give her freedom to move on to other companies if she wants to.
That's the fun problem with L1,
that's the upside. It's kind of looking at it. And then again, whether or not H4 EAD is a good idea now is your husband's H1B stable?
Yeah.
So those are items I would put in the mix that I do not know the answer to, and trying to help you figure out whether you want to do it now or later. Can I give you some thoughts? I don't see disadvantage between now and later legally, honestly, except that consider these options. Is your job stable? Is your husband's job, really mostly is your husband's job stable?
Yeah, I mean, but you highlight the thing I think is really important. It's, if I talk to people about, shaky times, scary times, Brian, what's the best thing to do? And if I hear somebody, well, you have your own independent visa, he has his own independent visa, primary visa, I would prefer you guys to keep that, because if something happens to his job, he can fall onto L2. He can work immediately on L2, not too shabby. And that's that. Obviously, love the flexibility of the H4 EAD, but yeah.
Who knows how long that is going to last?
Yeah, that was in my mind at the same time as well.
Yeah. And with the $100,000 H-1B, which may not be applicable to your husband, H-1B now has become a very shaky ship.
Yeah.
So L1 becomes valuable.
I had a consultation with an employer yesterday. Basically, they reached out maybe about 2 weeks ago trying to understand, like, hey, we've never brought people to the United States before. What does it look like? And I said, well, I'm feeling, you heard the news over the weekend, so, well, good news. I'm not here to talk to you about H-1Bs. I'm happy to talk to you about Ls, because the woman I talked to said, yes, we're aware of H-1Bs, and everybody in my company now is absolutely terrified of them because of what the weekend has looked like. So, yeah.
Is there any chance that the current EB1 will be scrapped with this new gold card process? Any impact on existing approved EB1 I-140? Excellent question. So they cannot scrap it, but they can certainly make it change the face of it, rearrange how it looks, because the president can't change the law. They only implement the law, but obviously the way they implement the law can make a big difference. But this golden visa itself, specifically, that executive order, will not scrap or impact the way the EB1 is going right now, except that you have more competition. If the executive order really ends up with handing out gold cards to people, then it's going to take numbers away.
Yeah, we were talking earlier, the backlog for EB1 India is not so bad, but if you find a bunch of money-heavy tech folks jumping from EB2 to EB1, suddenly those dates can slow down.
Yeah, I don't know why. Maybe EB2 national. I just don't get it. I just don't get it.
I don't understand. I don't understand the benefit. Who the EB2 category is helping there.
Yeah, but
for sure.
but Brian and I are doubtful that this gold card is going to end up in anything meaningful in the way it's presented now, based on just first reaction, I guess. Too early to tell reaction. So I'm not concerned about the EB1 visa being scrapped right now, to answer the question.
Yeah, I think there's a big old problem with just basically saying, oh, the EB1 category for everybody else is dead. I mean, it seems like lawsuits ahoy. There, what you guys get to do to tell me I'm eligible for a benefit and kill the law and not just sunset it, but basically scorch the entire earth of it would seem highly problematic.
Yes. Let's take the next one.
Yeah, let's see what we got here from the old immigrationquestions.us bin. Let's see here. Our priority date is October 2013. My husband is primary. My son and I are dependents. Husband had approved I-140 in EB2 and EB3. October 2020 I-485 filings for all three of them. Husband got green card in August 2022, EB2. My son and I are still in pending adjustment of status. My son is 19 years old now. My questions are we eligible to interfile to EB3 once final action dates become current in EB3? And if so, will his age still be locked?
Wow, that's a great question.
I have a word. I mean, I don't know how long their priority dates. Maybe their priority dates were no longer current for a chunk of time in EB2. But
so let's answer the first question. Sure. Can I interfile? So they have approved I-140 in EB2 and in EB3.
Yeah.
And I-140 filed, but did not clarify whether it filed under EB2 or EB3. I'm going to assume it was filed under EB.
You got his I-45 based upon an EB2. Yeah, I-140. Yeah.
Okay. So the first question is, can they interfile to EB3? The answer is when EB3 becomes current. The answer is absolutely yes, but I will when the EB3 becomes current.
I don't think so.
Why?
Because the husband got his green card in August 2022.
Received his green card already?
Yeah, that's where my jaw dropped.
I'm missing that
My
part.
husband got his green card in August 2022, EB2. So basically, these folks have been waiting for essentially 3 years.
And they because they retrogress.
They retrogress.
And they split the family.
Yeah, basically, your husband being the last guy to get in the door, green card for you. Push the button next time.
I missed that part.
Sorry, wife and child.
Yeah, my goodness. Well, that's massive. So
that's huge. Yeah.
No, you cannot interfile for EB2 to EB3.
Yeah, because husband gets green card in EB2. You guys are stuck in EB2 until kingdom come. That's it. That's how you guys get green cards. It's EB2 derivatives. You can't get into EB3. There's no other way about it. Yeah.
Wow, I'm shocked.
Yeah.
They did that to them.
Yeah.
He must be the last person.
That's where logic dictates. People were pushing buttons on the last day, and they pushed the button once for him, and
I would be prepared to
for
file
the
a written
family.
mandamus for all 2 cases.
That's the. I mean, as soon as their priority date is, but I mean, once their priority date's current, you hope that the government's going to act fast. But it's not crazy to, as soon as that priority date comes up, to file that writ of mandamus, because you don't know when the dates are going to retrogress again.
Now, are they subject to the protection under the Child Status Protection Act? Obviously, the visa is not available. They get the I-140 processing time. The I-45 is filed.
But I think he's going to be locked in.
They will get
He's
the date.
He's got to be locked in because his final
Became
action date was
current and
current,
then
and he applied for a green card.
And then it
obviously.
retrogress.
Yeah.
So if we do so, question number 2, meaning if we change to EB3, you will not be able to change to EB3.
Yeah.
So the CSPA question is irrelevant.
Yeah.
Well, that's an excellent question.
Well, yeah, but I think it's good to highlight the fact, though, that your CSPA counting is based upon the category that you're in. If you have older kids, you're thinking about doing a transfer underlying basis from EB2 to EB3. You have to think about, am I going to am I going to get a green card and accidentally boot my kiddos out of the process? Yeah.
With that, we hit our 6:30. And from R100, you're very welcome. We appreciate the nice commentary. And we will see you guys Monday at 6 o'clock. Hopefully we get more clarification on the $100,000 H-1B, because I don't think much has changed. And our prayers for the, I don't know if you read about the shooting down in Texas.
Yeah, ICE, geez, yeah.
And ICE, which is a terrible thing. I don't know, I think they're saying it's the second incident that happened at that location.
Yeah, violence is not good.
Violence does not